Welcome to Khanversations. I'm Muqtedar, your host, and as you can see, I have two very distinguished scholars as our guests today. We are going to talk about essentially international law and the war in Gaza. We're going to talk about South Africa's case against Israel on the issue of genocide in Gaza. We will talk about the International Criminal Court and its request to ICJ for warrants to arrest Netanyahu and the defense minister of Israel and other leaders of Hamas. So basically, we are going to try and look at the importance, the meaning, and the role of international law and international legal institutions, especially ICJ and ICC, in the conflict that is going on in the Middle East. We have with us from South Africa, Dr. Faith Mabera. Dr. Faith Mabera is a postdoctoral research fellow at the University of Witwatersrand in Johannesburg. In her previous role, she was a senior researcher at the Institute for Global Dialogue, a foreign policy think tank. Her research interests are vast. They include international peace and security, foreign policy, geopolitics, and international norms. Dr. Faith Mabera has a very interesting perspective. I've seen her in various seminars, and she usually asks very profound questions. Now she's at the other end where she will be answering some questions. We also have with us Dr. Lucas Lima, a professor of public international law at the Federal University of Minas Gerais in Brazil. He's the coordinator of the Brazilian Research Group of International Courts and Tribunals and has participated in proceedings before the ICJ. For those of you who are regular viewers of Khanversations and who also read the posts that I post in the community section, you will know that Lucas and I wrote an article about the BRICS, which was published in The Diplomat and read very widely, even got some responses from the State Department. So both of you, welcome to Khanversations. I must also add that both Lucas as well as Faith were part of the SUSI program at the University of Delaware in the summer of 2024. So without much ado, I'm going to jump straight away into the discussions. Faith, we'll start with you. A lot of people in the world were quite surprised when South Africa went to ICJ. They did not expect that coming from South Africa. Maybe they thought it would be the Arab League, if at all, or the OIC or others, but it was South Africa, which at first I too was surprised, but then I thought South Africa has been a leader in BRICS and other parts of major international institutions, punches way above its weight in international forums. So it was not a surprise. So did it come as a surprise to people in South Africa? And how do you see this entire task that South Africa has taken upon itself to uphold international law in this case?
Good morning to you, Dr. Khan. Good evening to the rest of the viewers who are in the different time zones. Thank you very much for having us on and for hosting such an interesting topic for conversation. So I think you get right to where the rubber meets the road in asking the questions about the motivations behind South Africa's application. So a bit of context, we know that in as much as the hearings themselves before the ICJ, the International Court of Justice, was sort of aired and took place in January. Actually, the case and the case itself was filed, the application was filed in December of 2023. So it followed significant diplomatic and legal groundwork. And it's also important for me to mention here that it came as a surprise for those who maybe had not anticipated that South Africa would take such a bold move, just in terms of the kind of diplomatic heft that such a move would demand. But in saying that, I think we shouldn't obscure the fact that the decision was also taking place against the backdrop of almost a coordination with other geopolitical action that South Africa was taking. Here I'm referring to how South Africa sort of pivoted off and sort of took the leverage off of its chairing of the BRICS presidency, which was in last year. It was chair of the BRICS. So what happened in November of 2023, 21st of November, in his capacity as chair of the BRICS, we saw President Ramaphosa convening an extraordinary meeting of BRICS Plus, in this case, the core members, Brazil, Russia, India, China, as well as the expanded members. So that would include your Argentina, your Iran, Saudi Arabia, but also in this case, UN Secretary General Guterres was also invited. And in this case, we saw a very sort of key communique, key outcome document saying that essentially amounting to a condemnation of acts of violence against the Palestinian people. So in a way, I think this was a telltale of what was to come then in leading up to that filing of the application. But from a broader perspective, South Africa's actions, I think, and to a large degree, were motivated by its own history of the anti-apartheid struggle. So it was, in fact, some would argue it is the only state that in this case would have sort of the moral authority to pursue such an action. So it took its cue from its history of the anti-apartheid struggle, which really tapped into global networks of solidarity, very close coordination with progressive forces across the world, and also linking up, as I've mentioned, with key geopolitical action. So this also takes into account that there was a need to really pursue and really keen and ramp up a key position within the international order. So this idea of South Africa then looking and fulfilling its characterization as a state that really punches above its diplomatic weight.
You know, what is interesting is that on second thoughts, like initially my reaction was also a bit of a surprise, and I said, wow, this is a very bold move. But then I realized that it is the most logical thing from a global perspective. The only country that has experienced both apartheid and colonial settler experience. If South Africa had not done this, then I think we should have lost faith in rule of law and international criminal court. I also remember in that meeting that you talked about BRICS, South Africa did not, Putin did not come because the ICC warrant were already out for him. Unlike other places like Mongolia, where Putin is able to travel and they are not enforcing. I'll come back to you in a moment, Faith, but I want to turn to Lucas. Lucas, tell us a little bit more about what is the legal status of this hearing, because we hear that the judgment will probably take many years to come, but we did have a provisional comment from the court. What are its, is it binding? And like, what is the power of this court, basically, other than say it's like a paper that is published?
Good morning, Dr. Khan. Good morning, Faith. For me, it's a pleasure to be in the Khanversations and to continue the conversation that we have started in Delaware this year. So essentially, this case was inspired by two other cases before the ICJ, Bangladesh, Myanmar, and Ukraine against Russia, where they used the Convention on Genocide, a very old convention, to say we have to halt, to have to stop some acts, and let's do it. We know that we're going to take a lot of time to discuss whether there is not or there is a genocide, but at least we can have a provisional measure, a kind of decision that it is binding, that can be used to put a lot of pressure. And what is interesting to see is that we had already 3 decisions on provisional measures by the ICJ and by the huge majority of the court. The first one was much more timid, I would say, just saying that it's important to avoid acts of genocide, but as the violence continued to grow in Gaza, the court changed its position. In the last order that was delivered in the 24th of May, the court expressly said Israel needs to halt its military offense. So you can see that the court moved from a more cautious approach to order Israel, saying you are risking very much the violation of this very important convention on genocide. And there is this important point that is plausibility. One of the criteria for the court is the rights protected in this kind of case must be plausible. And the court found that there is some plausibility that the acts committed in Gaza against the Palestinian people that the court characterizes as a group protected by the convention, there is this risk of rights being committed against. I think that it was only one judge that voted against, two judges that voted against this conclusion, which tells a lot, because in this kind of very sensitive cases, the court can be very divided. So in the future, Israel will have to deal either with the genocide allegations, but also with the potential violations of these orders.
And they are binding upon Israel, isn't it? The ICJ ruling.
Yes, it is binding. Yes, it's binding, and also the court is require Israel to send reports on its compliance with these orders. Of course, Israel is not respecting it at all, and there is some attacks on the court and on the legitimacy of the court. But in this specific case, there is no question of jurisdiction because Israel is part of the Genocide Convention.
That's very interesting. Faith, how are people in South Africa responding to this? Because I am sure that there is going to be backlash, not just from Israel. I don't know what damage Israel can do because there has been an ongoing tensions between Israel and South Africa over the use of the word apartheid, for example, for what is going on in Israel, especially in the West Bank. But the United States too, there is a possibility that there is going to be some kind of revenge foreign policy from the US on this issue. On top of that, given the fact that South Africa is part of BRICS and increasingly people here are beginning to see BRICS as a challenge to the global order, to the Western order. So is South Africa prepared for the consequences?
The answer that is becoming rather implicit and apparent is that yes, there was an expectation of the kind of flack that would be received by South Africa as a result of taking this particular course of action. But in saying that, I think it's a statement and it's a clear indication of conviction on one hand and courage to pursue this particular course of action. But there's actually, when you do a discourse analysis and how it's been perceived across our own local media here in South Africa, it's almost as if there is, on one hand, a very discernible popular support for South Africa's action. There's been commendable voices that have really sort of congratulated South Africa for taking this bold move. That's the broad sort of opinion across the board here in local terms and in local framings of the issue. But on one hand, we saw also that there's that very sustained campaign by, on one hand, Israel and also the US to try and pressure South Africa to sort of step down from this particular course of action and to maybe pull back on its pursuit of legal action of Israel at ICJ. And the fact that this was expected, just to also give you an example of the kind of pressure that South Africa was facing, the previous Minister of Foreign Affairs, Naledi Pandor, under whose tenure this case was filed, actually at some point she reported that her own family had been receiving threats and she herself had received death threats about this particular action. So it shows how just politicized that issue has become. But from our own sort of policy reading and assessment, from South Africa's own history and policy statements, it's almost as if there is broad-based support for it. And it's not surprising because of it's almost a taken for granted fact. It's a known fact, just the kind of relationship that the ANC, African National Congress, has had in terms of its support for the Palestinian cause. That's not something that has been up for debate in the public sphere here in South Africa. So it was not surprising that the ANC, of course, took up the mantle to press this particular course of action. I think what has been raised as an interesting question is whether there would be a dilution the commitment, given that now South Africa, under this current dispensation, is under coalitional government, and whether the other coalition parties, for instance, would sort of diminish or dilute the kind of resolve that South Africa had for pursuing this course of action. From the statements that I've seen of late, in fact, in his most sort of latest appearance, the current Minister for Foreign Affairs, Ronald Lamola, I think was being interviewed by MSNBC anchor Joy Reid the other day in Washington, and he said he actually confirmed an earlier statement that was put out by the South African presidency this week, actually, that South Africa will continue in its efforts to pursue the case, that South Africa will also file a memorial to in the coming month, which is October, to really sort of press on and indicate its continuance of this particular case and continue to receive whatever support. In fact, we've seen, and here I would be keen to hear also Lucas's perspective on the kind of uptake of so-called amicus briefs. So the statements that have been filed by a host, dozens of countries in support of not only advisory opinions, but also in support of the kind of applications that we've seen, particularly in this nature with the South African case. So I think South Africa's resolve remains undeterred, it remains robust. It's keen to continue in this action, and it's actually received considerable support, particularly from those of the global south, majority of countries who come from the global south, who are really giving voice and shaping up to be what we see a global south network of solidarity in pursuit of justice for the Palestinian cause and the Palestinian people.
You know, one of the interesting things is that all the BRIC countries except India are pretty much supportive of what South Africa is doing in this particular case. India is the outlier among the BRICS. India talks like South Africa, but acts like the US, which means that it will talk about the sufferings of the Palestinians, but sell weapons to Israel, and the suffering continues as a result of that. But I want to know a little bit about global north, this so-called wonderful, the priests and the saints among countries, Scandinavian countries, they always are supposedly pro-human rights, pro-democracy, etc. Norway has stepped up quite a bit in recognizing the Palestinian state, but are they also supporting South Africa in terms of filing briefs or even providing because this is a huge enterprise. Just documenting what is happening requires a large number of serious scholars because you can't just send in and say, we think this is happening. You have to document every allegation that you make, right? So are you getting any help from the northern countries, especially European countries who talk a lot about human rights, etc.?
So that's the irony here.
Sorry.
That's the irony here, Dr. Khan. Like I said, majority of support is actually stemming from the global south. So just to give you an example, we have countries like Spain, Mexico, Turkey, even countries like Lebanon. We have significant countries who are really backing up South Africa's position. And the majority, as I said, come from the global south, that this phenomenon in this particular trend among global south is in fact mirrored in the United Nations General Assembly. The latest vote that we saw earlier this week on the 18th of September saw about 126. Yeah, 126, which account for about 64% of UN states voted yes. Only 14% voted no, which is 7%. 43 abstained. Of course, there's a vast varied reasons for the ones who abstained, but when you look at the ones who voted decidedly no, siding with the US, it's almost microstates in a way. Who voted alongside
depend on the US for their survival,
Yeah.
Names
Yes.
never hear. The only time you hear the names is when there's a vote on Israel at the UN. Otherwise, their names never shows up in the newspapers or anything. Yeah, tiny microstates.
Yeah. So that underscores my point about the global south. And it really comes up against your own observation that you just said, that it paints in very stark terms how there is double standards with regard to the application of international law. And it brings up the question of those who back up the US-led hegemonic order and who, when faced with a pressure test of this kind, sort of really fall back to the hegemon's own geopolitical and imperial designs against, rather than taking up the greater collective good in a way.
Lucas, you were adding something?
Well, what is interesting here is that when the case was filed, there was a lot of support to South Africa, diplomatic notes, leaders of state. Lula said that was a great initiative. Our Minister of Foreign Affairs actively endorsed the initiative. But right now we are in a more serious phase. That is, where states that want to participate in the case. And we have already 8 states entering. Faith mentioned some. The fact that Spain is there, but not only Mexico, Colombia, Nicaragua, Chile, Turkey, they decided to participate and to give their view on the question of whether a genocide, how to interpret the genocide convention. And the great question behind this case is there a genocidal intent to characterize genocide? Otherwise, these are just war crimes or crimes against humanity, and the ICJ has no jurisdiction to deal with that. The ICJ can only deal with the genocide convention in relation to this case. But it's growing. So in September, Chile just said, I want to participate. And that, in my opinion, of course, this is global south, except from Spain. And Spain, if you read Spain's intervention, it's more or less pledges to take a softened approach to this idea of mens rea, this idea of genocidal intent. So I would interpret it as pro-Palestine and pro-South Africa. That means that states are really engaging in this proceeding. And this is quite rare. It happened only once in the Ukraine, Russia, where all the states in the European Union entered the proceedings to support Ukraine in the case. So essentially, we can see that states are using legal instruments to support this question. And if you look at the advisory opinion, I think that we are going to discuss that, the court was quite smart in not framing it on the attacks after 8 October 2023 in order to separate the legal questions. One legal question is the allegation of genocide, the violation of Genocide Convention, South Africa is leading, but also the question of the occupation. And the question of occupation is much easier to states to enter, to join, and to vote. And you have states like China supporting this kind of initiative that probably you're not going to see in the ICJ. So you can see different levels of legal actions depending on the question frame, which is quite interesting to observe at this moment in international law.
What Lucas is talking about is a request by the UN General Assembly to give an advisory opinion on the state of occupation of West Bank and Gaza, whether it is an occupation and what is the consequences of that occupation really. And could you tell us a little bit more about what it came out in July, right? And the request that the General Assembly had made was even before October 7th. So this is not connected directly to the current war, but even before that, the General Assembly was requesting ICJ's view of that. So could you just tell us exactly what did the court have to say? Because when I read commentaries, it says that the issue is settled, that this is indeed an occupation, even though in some countries, people talk as if West Bank and Gaza is an independent country. And so they talk about how Hamas, quote unquote, invaded Israel or as if it is being attacked from outside it. So could you tell us a little bit more about that, Lucas?
Yes. This is an important debate because since 1967, when Israel essentially occupied the West Bank, there is the discussion about which kind of rules would apply. If there is some control and the state is independent, so a certain set of rules will apply. Otherwise, it's the law of occupation. And occupying power has certain obligations. What the court said definitively after some discussions, because there are some debate of the acquisition of territory, people saying that some legal scholars sustaining that there was already acquired territory. The court said by 11 votes to 4 that no Israel continued presence in occupied Palestinian territory is illegal, and there is obligation to end its unlawful occupation, and there is also the need to repair all the damage caused to natural and legal persons. Imagine from 67 to nowadays, the amount of money that Israel will have to negotiate in order to repair all this illegal occupation. It's another set of pressures, and this advisory opinion came, I would say, with no surprise, because a lot of states intervene. Again, the international community decided to enter, to go to the court. They are not obliged to go to the court to explain the legal views, to say that UN resolutions at General Assembly and Security Council made it quite clear that this is an occupation. And now the General Assembly took again the question after the opinion was rendered and went further than the opinion, which is quite impressive, I would say, even suggesting that to create a mechanism for reparation of all this damage. This is a lot. And the court said, we are not going to discuss questions after October 8, 2023, because this is not what the General Assembly asked us. We're going to discuss only the occupation of Israel.
Lucas, for a lot of people who don't look at the details of international law and how it works, what the limitations are, as opposed to domestic law, which is backed by state coercive institutions, right? If I break a law in the United States, there will be police at my door within a few minutes. Whereas if you break international law, if it suits the United States, it'll try and impose and implement those rulings. And if it doesn't suit the United States, then there will be a campaign at basically maligning the courts, etc. So, but for somebody like you who looks at these things closely, do you see something optimistic about that we live in a world of where there is rule of law, or is this still a crazy jungle where you could commit genocidal wars and get away with it?
I think that there is a rule of law, but it's a different rule of law from a domestic legal system. And even domestic legal system, the notion of rule of law nowadays, we can doubt a little bit how effective it is. But the point, I think that the international justice and this kind of initiative has a different timing. They serve to recognize certain illegal situations that cannot be recognized and cannot continue like that. So there is a effect of freezing time, and freezing say, this is illegal, this is the standard that we should follow, and we were not going to accept. Look at the court. From 67, the court said there is an illegal occupation and there is certain issues that need to be resolved. So if you look to international law expecting an immediate reaction, I think that you'll be a little bit disappointed. But if you look in the long run, I think that there are important effects. Look at Chagos, look at other situations where when the governments change, it's possible to do something considering what international law, the General Assembly, the UN said. But the times are different, and you cannot expect to have something right now only because the court said 2 weeks ago that there is an illegal occupation. The point is, the next time there will be a negotiation, and diplomats know this very well, the legal argument comes to the table. And this is an important argument when you are in a negotiation.
Faith, I want to ask you a question about rule-based order. We talk about rule-based order. One of the things that Joe Biden has been saying repeatedly is that that his administration is going to restore a rule-based order. And whenever there's conversations about Russia and Ukraine, we talk about on one hand, the United States talks about the rule-based order. On the other hand, it is, threatening to sanction judges from the International Criminal Court. Karim Khan, who is, I guess, the prosecutor at ICC, has been threatened that his family will not be able to come to the U.S. There are threats against ICC itself. So what is happening? I mean, are there two systems in the world? Which is more important? So can you just flush out these contradictions between the rule-based order and international law?
Interesting that you asked that, Dr. Khan, because as it turns out, just in the aftermath of South Africa's initial filing, this was just after December 2023, we saw Professor John Dugat, who was the team leader of the South African team at the ICJ. He's a renowned professor of international law, serves on the UN Law Commission. And he authored a piece that was published in the Leiden Journal of International Law about questioning about what exactly the rules-based order is, and contrasting it with international law. Essentially, his core argument was that this concept of the rule-based order is a very amorphous concept, and in fact that it has no legal standing in international law. And the fact that this is a concept, if you really investigate how it came about, it's a concept that has often been invoked by the hegemon and powerful states, using the example here in this case of the US, which interestingly itself, the US is not a party to several significant multilateral treaties. It's not a party to the Rome Statute. It's not a party to the law of the Convention of the Seas. It's not even a party to the Convention against Genocide in respect to international humanitarian law. So it often invokes the rules-based order in service of shielding important allies, in this case, like Israel. So it will sort of bring up the rules-based order in really crafting up a space, almost like an exceptionalist discourse around which states should be painted as villains and which ones should be painted as the ones that are sort of saints or good citizens. But on the other hand, it's also increasingly invoking the rules-based order, interestingly, as an alternative to international law, as I said, in service of its own interests, in service of its own geopolitical designs. So this comes up against what we see as an interesting geopolitical fragmentation. The kind of contrast we see and the invocation of international law on one hand and the rules-based order on the other hand is in fact a function of what we see, the kind of fracturing, the kind of fragmentation that we see playing out in front of us in this context of an evolving international order. So it's almost what Russian Foreign Minister Lavrov alluded to in his address to the UN Security Council when Russia was chairing the UN Security Council in July, and he invoked the metaphor of the animal farm, where some animals are more equal than others. So this is what the rules-based order essentially is almost brought up to support. It's a very amorphous concept, and I'm inclined to agree with strictly legalistic and very academic discourses about how amorphous and ambiguous as a concept it really is.
If you were living in the Italian Quarter in New York in the 1930s, 40s, then if you were in trouble, you would either go to the police or you would go to the godfather of the mafia if you watched the movie Godfather. And to me, the Godfather's rule is like the rule-based order where he will administer justice in his own way, and then you have the international, the courts, regular police force, etc. So basically, we have two parallel systems, right? The rule-based order is essentially, I think it's an ideological way which protects Western hegemony, especially is used to advance U.S. interests overseas, and so countries which share U.S. interests often talk about this rule-based order. What is next for South Africa besides continuing with this case? In a broader sense, I think that there's no doubt now that when people talk about South Africa, that South Africa is the leader of the entire African continent. When we talk about expansion of the UN Security Council, while there is talk about the group of four, which is Japan, Germany, India, and Brazil, there is also those who say, well, if you're going to extend and expand the Security Council, then we should also include Africa, and then the automatic choice is South Africa or Nigeria. So is this a kind of, is this that we're going to see more such a normative leadership from South Africa on global issues, or is it just because of its peculiar history with apartheid that South Africa is taking the lead on this issue?
In a way, South Africa has historically played a very key role as a normative entrepreneur on not only this issue of justice and the Palestinian cause, but even when you look at a case like the promotion of concepts of soft law. So concepts like, for instance, your responsibility to protect. We saw South Africa also really being a key champion such evolving global norms. So it's really in line with its identity as a good international citizen. Some would argue its characterization of self-ascribed role as a middle power, and middle powers, by definition, they really champion their cause around multilateral action. It's also very much in line with its own foreign policy identity of supporting a kind of reform of the multilateral system towards more fairness, more equity, and a kind of sort of acknowledgement of just the distribution of power. So this reform of fairness, equitable, legitimate international and multilateral system is very much in line with its own foreign policy objectives and goals. But in saying that, I think the action by South Africa, in a way, when you look at it in terms of broader international law implications, on one hand, it really brought up a very interesting debate in broader conversation and garnered significant public interest around the role that international courts play as arenas for public debate for moral and political issues. But it also helped in sharpening the discourse around, as Lucas was talking about, the legal standard for genocide. And on the other hand, it raises up questions about, while its case was firmly focused on Israel's actions and with reference to genocidal intent, it also raises up an interesting question around complicity. So complicity of other states in genocide, most notably the US, which has been a key player in arming, in funding, and in shielding Israel. So this issue of complicity of other states in acts of genocide is important. And in fact, as you're probably aware of this, Dr. Khan, that there is an ongoing case in the US filed by the Center for Constitutional Rights in a US federal court, particularly around this issue of the US complicity in genocide. So it's this kind of additional elements, this kind of secondary effects of the application by South Africa, which I'm sure has far-reaching implications for international law and the evolution of really jurisdiction and international law on a broader scale. I think the implications are far-reaching and will go down in history as an important action and in support of its broader foreign policy, but also debate and discourse around global governance and multilateralism.
You know, Faith, I remember watching, I think it was Lindsey Graham, the senator, who while condemning the ICC for calling for warrants, basically said that if we allow ICC to issue warrants against Israel, they will be coming for us next, basically Americans, and he meant individually, because of this complicity issue that the United States is continuing to arm, fund, legally provide support. The metaphor that I use is, if you use my car, if you use my gun, if you use my bullets, if you use my credit card to go and commit crimes, am I responsible for it or not? Especially after I've seen what you're doing, but I continue to let you use my car, my guns, my money, my lawyer. Lucas, I want to turn to you and talk a little bit about ICC. When I talk to my students, I basically provide a very simple distinction. I say ICC is when individuals are involved, the International Criminal Court, and ICJ is when countries are involved. We go to ICJ. But can you tell us a little bit about this request for arrest warrants for Netanyahu and the defense minister of Israel, Gantz, and also 5 other Hamas leaders? And what are the chances that ICJ will accommodate ICC's request, and what happens beyond that, because we do know that Putin is a person against whom this warrant has been issued, but he seems to be trudging along. Yes, there are some places he can't go, but he seems to be unaffected by it. So could you shed some light on that issue and then tell us what it means?
Of course, and I think that your definition to your students is the same that I give to my students. So it's that's quite precise. So, but the real problem is state responsibility and individual responsibility, and you are dealing with set of rules, standards, and effects. And the ICC has not yet rendered this arrest warrant. This was required by the prosecutor. The prosecutor says that there's probably happening crimes against humanity and crimes of war in Gaza. The prosecutor did not mention the crime of genocide that is also on the statute. So probably any decision in relation to the ICC will not be taken strongly into consideration by the ICJ, because the ICJ, you are discussing the responsibility for the potential responsibility for genocide. And I think that it was strategically made on purpose to not go against Netanyahu in relation to a more divisible crime and go to the crimes that are probably happening and there is proof and you have enough to create a strong case. So the next step, now it's under decision, under the appreciation of the court. The court tends to be quick depending on certain political pressures, depending on the context. The arrest warrant against Vladimir Putin was quite quick, if you consider. But we probably are going to have in the next weeks the response to this request, especially because one, the prosecutor is making more pronouncements, putting more pressure, saying that this is very urgent. And second, this week, 2 or 3 days ago, Israel, or better, Netanyahu and the prime minister responded to the request of arrest warrant, which means that you have already the other party participating in the proceedings. And what they sustain is the ICC has no jurisdiction, there is no such a crimes, and Israel will not accept any kind of restriction. The point is that the obligation is not under Israel alone, but also all the other states that are part to the ICC that have to arrest or impede the person to arrive in its territory. And this creates a lot of problems. Certain states, like Mongolia with Putin, will disregard this kind of decision. But if you consider that European states tend to abide to the rule of law, tend to respect this kind of decisions, even the United Kingdom, this will create problems and will create diplomatic tensions in order to accommodate these potential visits. Probably Netanyahu is not planning many trips. The position of the US is, I'm not part, I can receive Netanyahu. This happened when we were in the US, right, Faith, when we were in Washington, and Netanyahu was there. So I think that one thing is he going to be arrested or not? This will follow long proceedings with proof, with evidence, defense. So even if he decides to participate or not, right now the defense is, I do not accept, but he can enter and say, I did not commit these crimes. But there is this implication on travels, the behavior of other states, and this create problems. For instance, in the case of Brazil, there is some discussions about this G20 BRICS meetings, etc., and there is an arrest warrant against Vladimir Putin. So how do you deal with a BRICS ally if you cannot receive it in your country? So it's very complicated, the question of the arrest warrant. There is some level of effectiveness, not in the question of is he going to be arrested, but all the following consequences to other states.
You know, it's interesting that you brought up the issue of Putin. When Turkey applied for membership in BRICS, Lavrov made a very interesting comment. He said that it's not a problem that Turkey is a member of NATO. But it is important that all members of BRICS are on the same page when it comes to the Ukraine issue, right? So that was an interesting point he was trying to make, and I don't think that Putin will be able to come to Brazil, because Brazil is also in the same situation as South Africa is, but maybe he can go to India, which is not India is like the US, right, on these issues. To the listeners, I want you to point out to you that there was a movie made by BBC several years ago called The Trial of Tony Blair. And it is an interesting movie. You should all watch it. It's also very funny. It's basically what happens is that there's an arrest warrant issued for Tony Blair, and the British ambassador to the UN Security Council decides that was exactly the time when he wanted to go to the bathroom. And so when the vote is taken, everybody thought that Britain will obviously veto it. And so the US did not do anything, and no other country does anything, and the British ambassador is not there. So it gets an abstain vote. And so the case moves forward against Tony Blair, and so on war crimes in Iraq, basically. So it's funny, but I think something like that could happen if the government changes in Israel. They might decide that in order to win back public opinion, to hand over Netanyahu to international courts. Who knows? We will see what that happens. But I want to thank both of you, Faith and Lucas, for joining us on Khanversations. We have already gone beyond our normal time, but I'm extremely grateful to both of you for enlightening us from both the geopolitical as well as legal situation. So thank you very much. And for those who are watching, please, if you've not already subscribed to Khanversations, please subscribe. But make sure you share this video with others, especially those who discuss international law, international relations, and foreign policy in their classes. Please make sure that this becomes part of your pedagogical tools. So thank you very much, both Faith and Lucas.
Thank you very much, Dr. Khan. Very nice to see you, Faith.
Thank you very much.
Thank you very much. Pleasure. And thank you for having us.
Thank you.